Well, hello, everyone. My name is Ron Weich, and I'm the Dean of the University of Baltimore School of Law. I'd like to welcome you to this evening's webinar, in which we're going to examine the kinds of litigation that we expect to see in relation to the COVID-19 pandemic. Over the next hour, three very knowledgeable and experienced panelists, all of them University of Baltimore Law School graduates, will share their understanding of COVID litigation, and I will serve as moderator for this discussion. Now, these webinars work well when it's interactive, so we very much look forward to your questions. And the way you should ask your questions is by submitting them using the Q&A function on your Zoom dashboard. I think we're all becoming experts in Zoom, so you all know how to do that. We'll get to as many of the questions that you ask as we can, but of course I'll lead off, get our panelists started. Now, before we begin tonight's event, I want to tell you about our next webinar. It's on Wednesday, August 27th. And this webinar is the second in a continuing series that we have started, examining structural racism, very important subject today. And the topic of the August 27th webinar is immigracism. How does immigration law manifest racism and impact immigrant communities? So this will be a lively panel, and our panelists will be alumni and friends who champion the work of immigrants. They will shed light on how policies at the border and within our country hinder immigrants' access to justice and human rights. The panel will be introduced and moderated by our own Professor Elizabeth Keys, who directs the Immigrant Rights Clinic and teaches immigration law. So now for our discussion today, as we talk about COVID-19 litigation, here are our three panelists, and I'll introduce them in order by their year of graduation from UB. First, we have Donald Kinsley, director in the Wilmington, Delaware firm of Marin, Marvel, Bradley, Anderson, and Tardy, LLC. Don is a 1991 graduate of UB Law. He concentrates his practice representing major corporations and individuals in complex cases involving product liability, toxic torts, construction law, employment cases, and others. Next, we have Imo Akpan. Imo is a principal with the Baltimore firm of Franklin and Prokopik, where he concentrates his litigation practice in the fields of transportation, retail, hospitality, and is involved in civil rights defense. Imo is a 2006 graduate of UB Law, and he was managing editor of the Intellectual Property Law Journal while he was here. Last but not least, we have Jonathan Novak, an attorney with the Dallas-based firm of Fears Machawati. Jonathan uses his background as a former DEA, Drug Enforcement Administration litigator, to advise clients in multiple areas, including opioid and mass torts litigation, contract disputes, and administrative law. Jonathan is a 2009 graduate of UB Law. So thank you all panelists for joining us, and thank you guests for joining as well. And now we will begin our discussion, and I'll lead it off by asking our three panelists, do you think it's right that we've called this webinar the calm before the storm? Chris Stutz, our communications director, and I had the thought that the litigation storm that one might expect from this kind of mass societal event hasn't yet hit. Are we going to see more litigation in the months and years ahead? And if so, what areas do you expect to be most impacted? What aspect of the pandemic is going to give rise to the most litigation? So let me ask, I'll do it in reverse order now. We'll start with Jonathan Novak. Jonathan, give us a sense of how you see the future of COVID-19 litigation.
Yeah, we're going to see effects of this for years, and I do think you're going to have a lot of personal injury related cases. But I think right now we're already seeing. In fact, just today there was another class action filed on behalf of businesses who are, like business interruption cases. There's been insurance coverage for business interruption that's not being paid out, and there's some sticky questions there that we're already seeing. If it goes the plaintiff's way, I think that's going to be a big part of what the litigation looks like in the future.
Mm-hmm. Okay. Emo, how do you see it?
Well, I always think that personal injury cases are going to be an aspect of the litigation that we're going to see going forward. It all depends on, I know we'll get to talk about this later, about the legislation that's currently pending before Congress about what they're going to do about liability protection, particularly for businesses and as it relates to consumers. I can tell you, though, that, and Jonathan's right, the majority of the cases that have been filed currently, only a small percentage of them have been personal injury cases. I think the first thing that needs to get fought out is business interruption insurance coverage. And then Honestly, I think once we get a handle, either a vaccine, I think we'll start to see, as we get back to normal, what the real scope or landscape of the litigation will be, whether it be personal injury, breach of contract, those sorts of things.
Okay, and Don, what do you think? Why is it that we haven't seen the full force of litigation yet? Is it that the courts are still, to some extent, closed, or is it that these cases take time to develop?
Well, I think it's a combination of the two. I think our firm and I think a lot of other firms are still learning to deal with this whole social distancing and addressing how you practice law. And during the pandemic, I'm one of the older panelists on this, and obviously it's new to me, it's new to everybody. I think everybody's still somewhat trying to get on their feet and get a handle on the litigation that they had ongoing before the pandemic, but now they've got to deal with all new litigation and different claims. As far as what I see, one of the key areas that are going to be litigated are the impact on the elder community, because I think they're one of the larger communities that have been affected by this pandemic. We all have, but as far as illness and death, and we're going to talk somewhat about the immunity statutes that have been passed, but and I think maybe I'm somewhat sensitive to that because my mother's in an assisted living facility, and I've had to deal with that on nearly a daily basis. But that, as well as employment issues, because employers everywhere are struggling to keep their customers happy, keep their employees happy, and try to make a buck. So I think you got a lot of issues there that are still going to
things coming down the pike. Yeah. So the issue, you say it's nursing homes, assisted living. That's one setting where we've certainly seen the virus take a very serious toll. And what kind of litigation would you expect there? Would it be a claim that somehow the nursing homes haven't done enough to protect their clients, their patients?
Yeah, I was just looking at a case today, a wrongful death case where one of the staff members was working who was positive, and then one of the residents subsequently died. Whether causation can be proved in that case, that's a whole nother question, but that's just one example.
Causation, look, we talk about that in first year torts classes. You all learned that at UB. How do you prove causation? No one knows where the virus, exactly where the virus came from in any one case. How do you ever prove that it was in the nursing home or in a department store or in a school? Jonathan, how would you go about establishing causation in a case like that?
It's going to be tricky, and I think you're going to see a lot of experts who are going to come in and talk about, basically contact tracing, but being able to get a full understanding of where a carrier got it and gave it to other people. I think that's a whole lot going to be difficult. I think the standard, the duty that's owed, is going to be a big question too, because we're seeing in Texas, for instance, the county executive, they're called county judges here, but they'll institute an order, and then the governor will supersede that order, saying you're not allowed to do that. You can't make people wear masks, et cetera. And at some point, there has to be a baseline standard of minimum a reasonable business to do, a reasonable person to do, in order to prevent harm to other people. So that's going to be a big mire to get through too.
I agree. So Emo, I'm representing a nursing home, and I'm going to tell my client, how do you do? Well, I didn't know about this virus. Of course, it came upon us suddenly. I took steps. I did everything I thought I should do. Why should I be held liable? Why is there any liability if a nursing home, say, took steps to protect against an illness that is, very persistent and got through the defenses?
So that's the big question. And I think the only thing we can do is take a look at how the courts have treated other communicable diseases like Legionnaires, like E. coli, foodborne illnesses, and the best comparison for coronavirus, particularly because it's a person-to-person transmission, and also because you have such large community spread where contact tracing makes it difficult, is that I think you're going to see when these personal injury lawsuits come out, they're going to be focused on areas where there were hotspots. So nursing homes where you have a sort of outbreak where you can really target and say, well, they've had 2, 3, 4, 50 cases in that location over a short period of time. I think it's going to be difficult if you just have a one-off in a grocery store or something like that. But as we saw, I think maybe it was the Smithfield meatpacking plant in the Midwest. I mean, those sorts of areas where you have a hot spot, I think is where you're going to see it a little bit easier to prove causation. But if you're a nursing home and you follow CDC guidelines, you followed WHO recommendations, I think you're going to be able to build a viable defense. But again, the landscape is changing, the laws are changing, the guidelines are changing. This is sort of the reason why we need Congress or the state legislatures, because Maryland hasn't said anything yet. The District of Columbia hasn't sort of said anything yet about establishing what is going to be the standard of care, or if there's going to be any protections for businesses.
And that's,
So
I just
Sure,
wanted to
Justin,
say,
go ahead.
I completely agree with all of that. And I think that to your bigger question at the beginning, I think that's why we're in a bit of a calm before the storm, because as an attorney, I have to have an actual standard of care or a law that I can point to and say, this is what was broken. This is what was violated. And right now, every day. So I think that's a big that's a big reason why we're not seeing these suits yet.
Mm-hmm. Don, I know one area where, considered one of the early hotspots was the cruise ships. And I take it that we've seen some litigation already arising from the conduct of those cruise ships. Is that right?
Yeah, we jumped on this early, and I think it was in April, writing articles. And one of the suits that I reviewed involved a suit against a cruise line, and where someone on the crew member aboard the cruise was tested positive, and the passengers were not made aware of that. So there were some allegations related to failure to warn. And I could see that to be another hotbed of litigation of anybody who was, I think I saw recently a suit that was dismissed where there was a suit regarding cruise line passengers who were alleging damages for fear related to contracting the virus. And that, from what I saw, was dismissed.
Yeah,
cruise
fear,
lines,
fear
obviously.
not enough.
Go ahead.
Yeah, I'm thinking the fear might not be enough, but if you actually got the virus, and of course it comes to the question of, did the cruise company know something that they should have and had a duty to reveal? Let me ask you guys about waivers. Very often when you buy a product or engage in some activity, let's say going on a cruise, or, entering a location, you might have to sign something, and typically there'll be that small print at the bottom where the proprietor tells you that you're assuming the risk and you waive any liability. Do those waiver provisions hold up, Emo, in your experience before COVID? Is that the kind of thing that businesses could rely on effectively?
It all depends on the nature of the agreement. So all of these exculpatory clause cases really turn on the facts of that particular case and the language of that agreement. And if I were advising any business, I would be revising any exculpatory clause language in any contract, particularly, let's say, for a gym, and make sure that the language, and this is typically what the cases turn on, is the language in the exculpatory clause specific to the harm that we're trying to waive or release. If it's not, or if the court says that it's not specific enough, then the agreement's not going to be enforceable. But if it is specific enough and then you're more likely that it is going to be enforceable. But it all depends again on the establishment. I think a gym is more likely than not to be able to have protection from an exculpatory clause, but a grocery store is not, because it provides a public service. So it really all depends on the specific location, the specific case. But it really, I mean, the cases turn on the language of this.
Interesting. Lots of different settings where this is going to arise. And let me, actually, we've already got a couple of questions from the audience that I want to turn to, but before that, I just want to kind of tie up one matter that came up a second ago. I don't know, Zemo, I think, said, well, if you're complying with or maybe Don said, if you're complying with the guidance from the CDC, the guidance that government agencies have provided, is that a sufficient defense? Is that going to be airtight against a claim of negligence? And Jonathan, I'm thinking of you, since you do opioid litigation and other pharmaceutical litigation and from the DEA. If a pharmaceutical company has complied with FDA regulations and gotten approval for a drug, is that an airtight defense, or is there still room for litigation and the claim of liability?
Ron, it makes me wonder if you maybe work for one of these companies. That defense gets raised.
I know a little something about it, but it didn't work for me.
Every single time. And as you explained, what we see is the defense is, all we were doing was selling a product that the federal government said was safe, and therefore you can't hold us liable. It has not hold water. I haven't seen that argument hold water in any court. It has not been a ground for dismissal that was granted, at least as far as I've seen. And I'm talking not only MDL, but also in the 8 cases. It is a little bit here, but that kind of thing doesn't just grant untouchable blanket immunity. I think what Emo and Don have both said, and what I think we're all getting to the heart of here, is the first thing has to be that there is an establishment of what's the guideline that people follow, and then the second step is going to be, did you comply with it? And that's going to govern all of this.
Yeah,
I think it's different because with controlled substances, that's something that's been heavily tested, et cetera, versus these guidelines. They're not going to be, I mean, it's just, this is our advice to you. So I think that it's a little rare when it comes, you're going to play out with the facts.
Yeah, and I just apologize to our audience. Jonathan's internet is a little bit shaky. We're hearing you, Jonathan. It's just a little bit choppy. There's nothing to do about it at this point, but I wanted to acknowledge it. And nothing to do.
Ron, if I could piggyback, if I could comment a little bit on what Jonathan said, and like I said, these cases are really going to turn, I think, not on standard of care, because it's always going to be evolving. And so you're going to get some expert that's going to say this is what it was required, and another one that's going to say this is what's required. I really do think it's going to turn on causation. And it's a little bit different than foodborne pathogens. It's a little bit different than Legionnaire's disease because of the person-to-person spread and the community spread. I was reading an article today that compared COVID-19 to influenza. And you don't see a lot of cases where people are suing because they got influenza either at work or those sorts of things. And not necessarily that we're there, but because it's novel, because it's new, it actually mirrors more so influenza as a disease from a liability standpoint than Legionnaire's, than West Nile virus, than norovirus. Like I said, causation and the way you do it in hot spots, I think, is where you're going to see it from the cruise ships, from the nursing homes. That's where I think the first set of litigation for personal injury is going to come from.
Yeah. All right, well, let's move on from personal injury and respond to one of the questions from our audience members. Mary Beth asks, can you speak to the business interruption claims? Don, give us a sense of what business interruption litigation would look like. Who are the parties in such a dispute?
Well, I could see a business owner suing any governmental agency to allow them to reopen. I think you could see employees filing suits against the employer if they're claiming some kind of employment impact as far as contracts, there's obviously going to be a lot of contract litigation between the different entities that are supplying these businesses. So I think when we talked before, we've written an article on force majeure clauses in contracts and how that's going to be interpreted, and how those kind of clauses are incorporated into the contracts.
I would tell you the dreaded word of a litigator, which is case by case basis. And so, because it's not just going to be about pandemic and whether or not the force majeure is exclusive or non-exclusive. Let's assume it is covered. The question becomes, can you actually specifically perform regardless of it? So that's going to be, well, we're in Maryland and the governor has decided these things are essential businesses and they're not, as opposed to maybe a place like Texas where the governor has allowed certain things to go on. So it is, the force majeure clauses are going to be a lot of litigation, but it's going to be case by case. It's going to be case specific. Obviously, if you're an essential business, that matters.
Yeah, one thing we teach our law students, you guys will remember, the facts matter. It's not just the case law. It's not just the holding of an appellate court. It's, what happened in this instance. Jonathan, have you seen force majeure cases that are relevant here? Oops, now we've lost Jonathan altogether.
Yeah, I think you froze. But Ron, you had mentioned sort of the business interruption.
Yeah, go ahead on business interruption.
And so doing a little bit of a canvas, I know that there was a case out of Michigan, and this being a business interruption claim against an insurer, where a business is saying, well, I've lost a certain amount of business profits, and I have, or believe I have, business interruption coverage under my policy. And the cases are going to turn on what is the definition of a physical loss to either to the business. And I think there was a case out of Michigan where they said COVID-19 and the pandemic didn't necessarily qualify, or the stopping of a business or the local municipality ordering a business closed is not a physical loss. Now, again, that was obviously case specific, but I think that's where you're going to see the business loss or business interruption cases or claims against insurers really turn on that issue.
All right, well, thanks. A couple of questions in the Q&A, and I encourage our audience members to put as many questions as you want. We'll get to as many as we can, thinking about different settings where litigation is going to arise. So an anonymous attendee asks, I would love to hear about litigation expectations at universities. All right, this is close to us here. Making people come to work or requiring students to sign off on waivers. What about the University of Texas at Austin that says they'll close if a student dies, but they don't list faculty or staff? So let's unpack that a little bit. If a university tries to bring people to campus, are they responsible if someone gets sick and is injured? Is that going to be enough? And some universities, including ours, University of Baltimore, is going to be largely remote. If a university goes in a different direction and tries to bring people to campus, are they exposing themselves to liability? Don, do you ever thought about that?
Well, I think you have to go on a case-by-case basis, as we were just discussing, but I think that's one of the key components that these universities are grappling with, and I know employers are doing the same thing if they require their employee to come to work. So university would be an employer, and if they require their employee to come to work and then the employee comes down with the disease, I think there is clearly a possibility there is some liability there. So
subject to causation, as we were saying before, you got to say you got it at the workplace as opposed to, in the subway on your way home.
Yeah, and that's, gets back to the whole causation question. I don't want to go completely back to that, but one thought that I wanted to add was the genetic testing. I anticipate that's going to come into play in this. We've seen it in a number of other toxic torts matters, and I think the science is still catching up with this pandemic and virus. And from what I understand, there are different mutations to the virus, and they are able to genetically map the different mutations. And if you can use that to tie the person's illness or disease to that particular virus, and then you can tie that back to someone else at the place of employment or school, university, I think that takes at least a step further in proving your case.
Yeah, so that suggests that we're going to have to find experts. Plaintiffs' lawyers are going to have to identify experts here. And our one of our anonymous attendees asked a question that I'll direct to Jonathan now that he's back with us. The question is, what if someone gets COVID-19? They suspect it to be something they contracted at work. Are there experts out there who can testify about COVID? Who is an expert? A pulmonologist, an infectious disease specialist, a researcher? How accessible are these experts if they're not your typical board certified pulmonologist, for example? Jonathan, how would you go about finding experts if you're on the plaintiff side of an injury case involving the virus?
Thank you. Sorry for the interruption there. I think it starts with the kind of experts that we use in some of our in plaintiff style cases. Medical experts that I've worked with in opioids, or medical experts I've worked with on causation issues for medical devices. But I do think you have to start looking at, people who study infectious diseases and how they spread. I think that's going to be absolutely mandatory. And I think that this is going to be a new field where there's going to be a lot of people starting to establish themselves. That's another problematic aspect of these, because you don't want to be the first one to put a expert on the stand and then have them not get qualified and blow your whole case. So that part's going to be a little frightening for us plaintiffs firms.
I take it in litigation, litigators typically share information. Here's an expert who did a great job in this case, in this district, and then other litigators will reach out. And then these experts kind of make a living doing that, although there's a danger there if they're seen as only plaintiff side experts and question their impartiality. So that's going to be an issue. Let's turn now to that issue of the federal liability shield. We raised it early on, but I think it's important to all of this. Congress is talking about maybe putting some guardrails around this litigation. Senator McConnell, the Senate Majority Leader in particular, has said that for him, it's an absolute necessity in the next big congressional bill that there be some federal liability protection. Is that going to halt the litigation, or are litigators going to find their way around it? Emo, how do you think that'll go?
Well, I think litigators are creative, and they're always going to find their way around it. And from what I've seen, the sort of turning point is going to be gross negligence. So any liability protection is only going to protect for negligence. If there's gross negligence or any intentional or willful or wanton conduct, that's still going to subject the business to potential liability, and you can almost certainly believe that any complaint is going to include those magic words that it's gross negligence as opposed to just regular negligence. So the liability protection, I think, is important just for the legal landscape of everyone understanding what it is and what it's not. I know that Majority Leader Pelosi has suggested something less of you have nothing to worry about if you comply with OSHA standards or the CDC guidelines. But I mean, if there's no federal protection, we're going to see lawsuits. And I think lawyers are going to sort of figure out and build a legal framework for whether or not these cases have value or don't.
Jonathan or Don, do you agree that that's how lawyers are going to approach the federal law? They'll find ways to plead the case that satisfies the statute?
Well, there will obviously be some experimental cases that'll go forward, testing any immunity protections provided by either the federal or state governments. But I agree that gross negligence is it's going to be a question of the facts of the case and what facts are used to make that kind of case. I was reading an article today about that immunity protections that are being provided, and the people on the plaintiff side of the V are concerned that that it may be giving either nursing homes or some other entities more protection than they really should have. So you can be sure that there are two sides to that coin.
Jonathan, do you think there's a bright line between negligence and gross negligence?
First of all, I absolutely do, based on my law school education. But I think that is exactly, Don's pointing out what my fears are as well, which is utilizing these protections, which at their heart are designed for us in part to help open the economy up again. Very important, obviously. But we can't then craft these in a way that provides, and I like how Don said it, too much protection, more protection than's necessary when there are cases where it's clearly gross negligence. And the big fear would be that we're going to, it's going to be it's going to be a chilling effect on people interested in filing these suits, because a lot of firms are going to have to throw a lot of spaghetti at the wall to see what'll stick. And that takes a lot of time and energy and effort. In the end, it's so that we can represent harmed parties. But on the front end, we have to kind of poke around and see what kind of liability protection there's going to be. I'm afraid of the overreach on this one.
Yeah, so you're afraid it will be what?
The overreach.
Oh, they'll protect too much. Yeah.
Mm-hmm.
There was a time in the 80s when there were lawsuits arising from injuries related from vaccines. And Congress enacted very sweeping protection and created a trust fund, basically a compensation system outside of the tort system, where, of course, this could be relevant if we get to a COVID vaccine. But more generally, there was a time when Congress stepped in. There was then talk later in the early 2000s about a asbestos trust fund that never came into fruition. Is there any chance that we're going to see that kind of sweeping protection just wiping out tort suits across the board? And if you see that on the horizon?
There's always a possibility. It comes up when you have just so much litigation that it bogs down the system. And right now, the system is very bogged down. It is
bogged down for other reasons.
Yeah. If I would say it depends on the economic impact. So if we stay closed as a country, if you will, for an extended period of time, and it has a significant impact on the economy, I think you're more likely to see sweeping regulation or a sweeping protection to get the economy started, to give some sort of peace of mind to businesses to open. But if we come back sooner and the vaccines sooner, I think it maybe changes the story. So, it is, like I said, it's a new virus, and how we approach it is going to be all novel as well.
Okay. Let's come back to the contract law questions, because we have a question from participant Brad McCullough. It says, could someone address the doctrines of impossibility of performance and frustration of purpose, and how that might affect contract claims? So I'm trying to think back to my tort class too long ago. How does the doctrine of impossibility relate to force majeure? Is that something other than act of God?
So I was working on a case, and I presented this in and I didn't learn this in law school, but the strongly worded letter, which is really the most useful tool in the lawyer's tool belt. But I was drafting a letter, and I presented the force majeure argument, but then separately the argument of impossibility of performance. Regardless of the cause of the impossibility, this was in a case about a wedding venue, that regardless of what caused it, they were no longer going to be able to host a wedding with the appropriate number of guests based on the state ordinances. So my argument was, well, then you can't fulfill your side of the contract. It's an impossibility, and it's a wedding. So you can't say, well, we can do 15 people instead of 300 people. You can't perform on your side.
That's not the product that I bargained for.
Exactly. So I think that at least it has, as I've been handling it, they're two separate things, but you get kind of two punches there if you're arguing on behalf of a client who isn't able to get what they were seeking out of their contract.
Yeah. And in the business law context, are we going to see litigation against banks and insurance companies for their role in this? Let's banks were giving people, filing applications under the payroll protection program. Let's say somebody didn't get it. Is that a piece of litigation that we might see, saying you didn't get me the government grant that I asked you to get me? Don, is that something you would anticipate?
I can see that. As far as suits against insurance company, we've already seen some suits involving business interruption. The law firm in Philadelphia, I know, sued their insurer based on business interruption insurance. A court reporting company also sued its insurer in Philadelphia under a business interruption claim. So yeah, I think there's going to be a ton of that litigation, and none of us are, I don't think, bankruptcy experts, but there's
I was going to say,
really going to be a lot of bankruptcy claims.
Right, we haven't gotten to that part of the story yet, but there's tremendous economic dislocation from this virus. Already in Baltimore, we've seen many restaurants and businesses close permanently, not just temporarily. And so if bankruptcy laws are invoked, we all know there's litigation that can arise from that as creditors are fighting over the assets. Another set of this. Business interruption, I'm going to take this in a different direction. I want to ask how your businesses have been interrupted. I'm looking at your backgrounds, and I have this sense that you guys might be in your offices. Are you actually live in a law office? Because if so, you're better than me. I'm sitting at home. Emo, you're in your office, right?
Yes, I'm in my office, and it has had a huge impact on our office and day to day. I mean, I'll say this: we have been lucky in terms of it hasn't slowed us down too much, but we had to change, and all of our lawyers are essentially asked to work from home unless necessary. We've created a skeleton crew of secretaries and administrative assistants that come in. Our office is large enough where social distancing isn't a problem in terms of where offices are spaced or where staff is spaced. But there's so many things that you can do. I noticed today when I went to the bathroom that there's a step door opener, not so you don't have to touch the door. Which is something I hadn't seen last week. From elevators with spots to stand. We are in new territory, but it's interesting to think about it from the liability aspects and why these things are done.
Yep. Don, where are you working?
I'm in my office, but to be honest with you, this is probably the second time I've been in my office in the last 3 months. And the main reason I'm in my office is because I lost power at home because of the storm that blew up the coast earlier this week, and still without power at home. So I wanted to have internet access for this webinar. But
Thank you for that. Thanks.
Yeah,
you managed to carry on remotely. You're able to do your work largely from home.
Yeah, well, even before the pandemic, at least my practice is primarily I can perform it over the internet. I do a lot of depositions. A lot of those are done over the phone, and now we're doing a lot of Zoom depositions. I think it was April. I participated in one of the first hearings here in Delaware in the Superior Court, arguing summary judgment motions via Zoom. And to be honest with you, I think everybody was pleasantly surprised at how well it went. And we really didn't have, I think there were probably a couple little technical glitches, but we overcame those, and the judge was happy with the result. And I guess we're going to see more and more of that as far as judicial hearings. Now trials are going to be a whole.
Well, that strikes me as the ultimate question. Are we going to see Zoom trials? Jonathan, first let me ask you where you are, and then tell us whether we're going to see Zoom trials.
I'm working from home and have been, as Don said, I think I've been in the office twice in the last 4 months. It's taken some getting used to. And I think to the first question of kind of how this impacts the practice and how we practice, I lovingly say that the law is a Luddite in and of itself. Very, very slow to embrace technology. When I was at DEA, we actually had two options for serving the court with copies of things. It was either you could hand deliver it or you could fax it, and that was it. You couldn't email. That's the kind of behind it. Or I've had partners who would get an email and then print them out so that they could write on them. We're not a technology opposed group, but we're not really at the forefront either.
I still have a stash of yellow legal pads.
I got one right behind me here. But everything I think the first month for everybody was weird, getting through not only a global pandemic, but also how do I work from home in this profession where normally I'm in front of people talking to them. That's, as a litigator, that's a lot of what I do, and my dog is very tired of it at this point. But
I have a cat. I locked my cat in the basement so it wouldn't be meowing during the webinar. Jonathan, let me ask you this: Zoom trials, isn't that a bridge too far? I mean, the technology gets you like this. We can talk to each other. I can see Don conducting a deposition, but a trial where you've got witnesses and a jury that's going to have to deliberate, could that possibly happen over the internet?
Personally, and I've seen attempts at this with hearings, so much of what we do is not just the words that are coming out of our mouths or the witnesses' mouths, but we read body language. We read the way that people are communicating to each other. It's a big part of what we're doing to try to understand. And that technology, it's not here yet. I love the idea of being able to do it, but I don't think you can fairly get all the facts and all the information into a case. I don't think a Zoom version of a PowerPoint is as powerful as someone in a courtroom holding an object up to a jury to see. And it's probably inevitable, but at this point, we're not there yet.
Yeah. I'm thinking which of you guys practice in Baltimore, because I assume many of our audience members are here in Maryland, either in state court or federal court. Don, you were telling us the other day that you had some litigation in federal court in Baltimore. And Emo, your practice is part local, yes?
Yes, my office is in Baltimore. I'm also barred in Washington, D.C. But
so what do you see locally?
Locally, everyone is doing the court. So locally here in Maryland, the circuit courts are supposed to reopen in phase 5, October the 5th, for sort of full courthouse, potentially for jury trials. I am pessimistic that any of the jurisdictions are really going to do in-person jury trials in 2020. I think one of the things, and this is particularly important for civil cases, is that what we've seen is that the courts have generally prioritized criminal cases over civil cases, simply because obviously if you're holding someone against their will, that's more important than civil cases about money or breach of contract or slip and falls. But one of the issues that we're going to have to wrestle with is, particularly for the plaintiff's bar, are you going to demand a jury trial or not? Because could you potentially get a bench trial sooner, faster? Can you do, I think a judge would say, yeah, I could do a bench trial over Zoom. Certainly can. So, I mean, all of these options, all of these things are going to sort of involve the day-to-day decision of lawyers. Do I demand a jury trial? Do we get consent to proceed by court trial? All sorts of things. So it's interesting. But right here in Maryland, we're just sort of kind of, I think the clerk's office are just trying to figure it out in the lead up to the opening in October.
I've heard Chief Judge Berdar in Federal District Court here in Maryland talk about how they're reconfiguring. They haven't done it yet. They haven't had a proceeding. They're actually rearranging the furniture in the courtroom, and they'll put smaller cases in larger courtrooms to achieve distancing, bringing in the plexiglass, and envisioning jurors actually being there. So that would be live. Zoom trials, I don't know. Don, do you think there's a chance of that?
Yeah, I have my doubts. I was reading about a trial in California where rather than have the jury, I think they proceeded with the trial, and rather than have the jury go to a jury room to deliberate, they kept them in the courtrooms, which was a bigger space, so they could social distance while they deliberated, and then they closed the courtroom and just made that the jury room. But speaking about plexiglass, we had a deposition that we tried to move forward with mask and plexiglass. That was the first time we had gone from Zoom to an in-person deposition here in Delaware. And what happened was the court reporter basically couldn't understand what the witness was saying because they were wearing a mask. So then it quickly just transformed into a Zoom deposition. So
I don't know about all of you. Have you seen this? This happens in, grocery stores and so forth, where someone is talking through a mask, they can't be understood, so they pull down their mask to say what they want to say, and it defeated the purpose of the mask. So we don't want to see that.
right.
Here's a practical question from one of our participants. And again, I encourage any participant to put a question in the Q&A. We've got about 10, 15 minutes left, so still time to get your question answered. But let's focus on this one from Donna McElroy. She says, now that you're discussing the possibility of remote trials, I'd like to share with you a concern. My work is primarily in child welfare. And when we're conducting remote shelter hearings, there's no way for me as the parent's attorney to answer on behalf of my client or to control his or her outburst. Any idea how this is actually going to work? So let's generalize it and talk, how does a lawyer interact with a remote client? That's a challenge, isn't it?
If I can
tackle that one.
If I can take first bite at this one, I believe
Sure.
Donna McElroy is actually a UB law graduate herself.
I'm sure, that's great.
Also has a son that worked at DEA.
All right. So tell us what you think about the remote client problem.
That's a really interesting problem because I'm not used to dealing with clients that I need to control outbursts from, but that's an area of the law where that is absolutely mandatory. And unless you create tiers of like the lawyer, how only like one person can share the screen on Zoom, maybe the lawyer has the ability to mute their client and turn their camera off, because otherwise I don't know what you do or how you control a client from giving an outburst when you're not sitting next to them.
Yeah. Any thoughts, Emo or Don, on this aspect of things?
I mean, if
Go ahead.
go ahead. Oh, if it were me, I would want to find a way to be in the same room with my client because I don't think that there's any way that you can structure the technology aside from what Jonathan suggested, that you have the ability to mute or turn off the screen of your client, that I be in the same room as them. One of the things, actually, I was talking to a colleague yesterday, and he brought up a concern about doing Zoom depositions with attorneys in the same room as clients and not knowing whether or not that attorney who might be off camera is coaching the witness. I mean, there are all sorts of issues that are brought up by doing and using the technology that I don't think, obviously, that the legal community has figured out.
Nope. We may have to if this thing drags on for months. I mean, as you've said, if nothing else, criminal trials have to be, criminal matters have to be resolved by trial or otherwise. I take it that some criminal defendants are getting better plea offers because the government can't put them to trial. And then there are prisoners who are getting out. There's litigation for who gets out of prison, right? It's that kind of case already.
I think it depends on the litigation, because I've had some cases that I had a case that started before the pandemic and resolved during the pandemic. And talking about meeting your client, I never met my client. It was all by phone, and we resolved the case and using emails and telephone and.
That was a business law dispute. So it was a money.
No, that was a personal injury matter down in Maryland. But I guess you gotta do what you gotta do. I think one of the last things I did before this pandemic was a site inspection, inspecting a transformer here in Delaware, and we had experts taking the thing apart. And during that whole time, I was wondering, should we be standing this close to each other? I mean, nobody was shaking hands, but probably at that point we shouldn't have been standing as close to each other as we were. But you've got those kinds of things that are going to happen, where you have to go out and do site inspections and try the social distance and either that or examine pieces of equipment with your experts, and that kind of thing obviously has to be done in person. I guess you can try and do it by video, but I would think it's got to be done in person.
Okay, there's another question about the school setting and how that gives rise to litigation. And I wonder if you guys have noticed there's litigation underway and perhaps expanding in Montgomery County, where the county was trying to say that all schools had to be remote, including private schools. The governor attempted to asserted authority to overturn that decision and said that each school should get to decide. And one of UB Law's finest graduates, Tim Maloney, sued on behalf of the schools, saying that they should be able to be open. So that raises this question of whether these restrictions are different kinds, whether the masks or which businesses can be open or whether churches can be open. How much litigation? We've seen some litigation already. The church cases have actually reached the Supreme Court. But is that going to continue to be an area of litigation? How much can government regulate conduct to protect against infection? Do we see that as a growing area, Jonathan?
Absolutely. And we're going to see in court kind of the very heart of, states' rights or county rights or
yeah, I'll pick up
he
on
was
that.
going to pinch it here.
I'll pinch it
against the federal government or against just a larger governmental authority. So,
go ahead, Ian.
Yeah, no, I'll piggyback on what Jonathan said. I do think we're going to see those suits, but just if we take an indication of what the Supreme Court decisions have been about the church cases, I think the court, particularly in a situation of a new virus that we don't have a hold on, they're going to side with government saying, yes, you can do this to protect larger society. I think the court is going to defer to the governor's orders, to the executive orders for protecting the public.
Yeah. Don, you ever thought about these restrictions? Is it possible for government to kind of tighten the screws too much and get blowback in the courts?
Oh, yeah, I certainly agree with all the comments. When this whole thing started, I first was a little bit taken aback because it seemed like litigation was going to come to a standstill. All the depositions stopped. I was wondering how I was going to get my billable hours. But now I think this pandemic is probably going to be full employment of attorneys disease. And if I was a new graduate, I would make it a point to become familiar with every aspect of COVID as I can and become an expert in the area. And I think you're going to find excellent employment.
Well, that raises
because we have such a litigious society. So
yeah, I was going to ask this, and maybe it's a good place to start to wrap up. Full employment for lawyers, lots of opportunities to sue. This is something a little bit discomforting because we all know this is a tragedy, a national tragedy. 150,000 lives lost so far in the U.S., many more around the globe. In legal circles, in law schools and elsewhere, we are thinking, this is a way our graduates are going to work. But how does this affect the image of lawyers? What is the role of lawyers? What should the public understand about the role of lawyers? Are we just ambulance chasers, or in this case, virus chasers, looking for plaintiffs who have been harmed by this terrible virus, or are we doing something else? How do you see the role of lawyers in this situation? Jonathan?
Hopefully I don't freeze up again this time.
You're doing okay.
Okay. I struggle with this question a lot in my everyday practice because I work against entities that have harmed people, and I want to make people whole. I want to do what I can to make sure that they can't do that ever again. And I'm sure they'll find new things, but there is the flip side of it where I'm getting paid for my services and I want to have a lot of business. There's a grotesqueness to what lawyers do in general that you can't shy away from. I think though that this is another example of I'm looking forward to stepping up to defend or to represent people who were harmed. I'm looking forward to represent who it's coming from a good place. It's coming from a place of lawyers are able to step in and help people who can't do it themselves. And I think that a lot of what we're seeing right now is still trying to figure out who's to blame for mistakes that were made. Some of these no one could have prepared for, and some of these we could have. And I think it's our duty. I get starry-eyed about it all the time, but I think it's our duty to ask these questions and challenge these things in relation to COVID and 150,000 Americans being dead already. And we don't know when this is going to stop.
Yeah, that's very thoughtful. Don, you've been at this for a very long time. Are you comfortable with the role of lawyers in situations like this? You've been involved in other kind of serious tort cases. Is this one?
Yeah, I guess I don't see a significant difference. I haven't seen any ads yet on TV looking for COVID plaintiffs, but I certainly suspect they're in the works, and we will see those. I just think this is another aspect of our litigious society here, and that's just the way it is. I think we're going to see more and more litigation related to this. Obviously, people are dying and people are sick, and it's a shame that happens. But you're always going to have attorneys who are going to be pursuing their rights, and you're going to have attorneys on the other side defending the defendants who feel like they did everything they could, and you've got the medical care people on the ground who are making those life and death decisions on a daily basis, and it's a difficult situation.
Yeah, Emo, you get the last word on this. How do you see your role in this current crisis?
If I could, in this time of great death, if I can put a positive spin on the profession of being a lawyer, I think this is a novel time where lawyers are going to be at the forefront of figuring out how society governs itself. And so we're going to necessarily decide, sans Congress stepping in, who should be held responsible, who shouldn't, what should be done and what shouldn't be done. And I think that's the uniqueness of being a lawyer, being in the litigation, in the court system, that we're going to be tasked with, well, not necessarily solving society's problems, but figuring out how we conduct ourselves and how we govern ourselves, and what we say is wrong and what we say is right, and what should be redressed and what shouldn't be. So that's the beauty of it. And I hope that that's something that the large society thanks lawyers for, but if they don't, well, I guess we'll still do our jobs.
Right. I'm glad to hear that all three of you are comfortable with the role of the profession. I am. We have orientation for our new students coming up in 2 weeks. And what I'm going to tell them, as I tell every incoming class, is a law degree is a license to help. And you can help in so many different ways. If you're on the plaintiff side, you're helping someone who's been injured, try and get redress for damages. If you're on the defense side, you're protecting business or as an individual from unjustified liability and making sure that a business isn't harmed by unjustified litigation. In general, I agree with you, Emo, that this is about the peaceful resolution of disputes. That's what characterizes our legal system. That's why it's so majestic. Lawyers are indispensable to the task of sorting out these disputes. We don't solve this with knives and guns and stones. We go into court when they're open, or we resort to Zoom when they're not, to reach a resolution of these disputes peacefully. And so I'm telling our students they're entering a great profession, and I'm glad to see that all of you are doing the work that you're doing and representing UB so nobly as graduates of our law school. So thank you all very much. Let me ask if any of you have any final words. I'll give you another minute if anybody's got anything more to say.
I just want to thank you, Ron, for helping put this together and leading a spirited discussion. I appreciate it.
My pleasure. Thank you all. Jason Keller, our Director of Alumni Affairs, who all the alumni on the call should know well. Jason has put in the chat a link to the schedule of future webinars. I mentioned the immigration one coming up, but we're going to keep doing this because we want to keep our community informed and engaged, and we'll keep bringing back wonderful alumni like Emo and Don and Jonathan. We thank Chris Stutz, our Communications Director, for her great work in pulling these together. And thanks to our participants for being here. Come back next time for more UB in Focus. Thank you all very much, and good night.